The defense offered my client $1 million to settle her case. When I called her to tell her, you know what she said? Absolutely not. I will not accept that. That is not an acceptable number. You want to know what I said to her? You want to know about our discussion? Come join me for a walk through the neighborhood as I'm heading to the train this morning on the way to the office as I share with you the answers to those questions. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. My client brought a medical malpractice case against a careless doctor. And now, as the case was approaching trial, the defense reached out and said, listen, we'd like to try and negotiate. After a few days of negotiation, they finally came to $1 million. Now, I knew that my client wanted more money than what they had offered. I knew that my client was not going to accept the $1 million. So you might be thinking, okay, why would I even then have a discussion with my client about the $1 million? It's because I have an ethical obligation to report back to my client, to let her know about what they offered, to talk to her about the risks of accepting the offer, yes, accepting, the risks of not accepting the offer, what are the alternatives to that? So let me go through them with you. So when she turned around and said, I am not going to accept $1 million, my case is worth $10 million. And you know what I said to her? I said, what do you base that opinion on? What do you base that conclusion on? And you know what she said? She couldn't give me a coherent answer as to why she thought her case was worth $10 million. The first thing she said was, well, I know that my neighbor brought a case and my neighbor got X millions of dollars. That was the first thing she said. Then she turns around and says, you know what? I read in the paper that this person brought a lawsuit against this person in a different state and was able to recover X millions of dollars. That was the second thing she said to me. So here she's trying to come up with excuses and reasons why to justify her demand that this case is worth $10 million and she won't take a penny less. Now, is that appropriate? Well, regardless of whether it is or isn't appropriate, the fact is for this particular case, we had a substantial offer of $1 million. Now, did I actually recommend that to her, to take that money? No, I did not, because I also thought that her case was worth more than $1 million. But was it worth $10 million? In my opinion, absolutely not. So you might be thinking, okay, what are the risks of accepting this offer? Well, the risks are, if you accept the offer, your case is done and you cannot come back and ask for more money at a later time. So now you're thinking, okay, I have to pay back the attorney's expenses for prosecuting my case, for laying all the money out over the course of the litigation, and now I have to give him a percentage of the money that we recover. So you walk away with only a fraction of the settlement amount. And then down the road, months later, now you realize you should have held out for more. You should have gone to trial. You should have done all of these things. Well, maybe you should. But then again, maybe you shouldn't. There's a lot that goes into answering whether or not a settlement offer is appropriate for you and your particular case. So what other risks are there? The risks are that you turn down the offer, and now you have no choice but to go to trial. When you go to trial, it's an unknown. You don't know what the ultimate outcome is going to be when you go to trial. And by the way, neither does the defense. You may think you have the best case in the world, and you may. However, a jury may disagree. In that instance, a jury may give you nothing. And you're thinking, that's impossible. I have a great case. Look at this. They offered $1 million. How could a jury turn around and give me nothing? Well, the jury may not like you. They may not like your experts. They may not like your theory of the case. They may believe the doctor and his attorney much more over you and your claims. In that instance, there is the possibility that they will come to the conclusion that your doctor was not careless. Even if they decide that he was careless, they may come to the conclusion that whatever he did wrong did not cause or contribute to your injuries. Or they may turn around and say, you know what? We think the doctor was careless, and we think that his carelessness was a cause of your injury, but we don't think your injuries are that significant, and we don't think that they're permanent. We think you might be exaggerating your injuries, in which case they give you much, much less than the offer that you were provided prior to going to trial. In which case, now you have a significant problem. But that's part of the risk that you have to evaluate when deciding whether or not to accept the defense's offer. I turn around and I go ahead and do research, legal research, to show you what other cases, similar cases, have settled for, what other similar cases have gone to verdict for, what other similar cases have gone up on appeal, meaning that it's gone to trial, a jury has reached a decision, and now an appellate court has made a final decision about whether or not that verdict is appropriate. The appellate court decisions in a similar case are very, very useful to help us evaluate whether or not the injuries that you suffered are worth a particular amount of money. So if I came back and told you that on the best day, my legal research concludes that your case may be worth $1.5 million, $1.75 million, and you are still adamant, you are still furious, you believe in your heart of hearts, in your mind, in your heart, that your case is worth $10 million, and you reject the offer, I have to tell you that you now run the risk of losing it all. You run the risk of basically going to Las Vegas, going to a casino, taking all that money and putting it on one particular number, let's say on the roulette wheel. And now you're hoping, against the odds, that you will win whatever it is that you're playing, whether it's blackjack or craps or roulette. And now you are putting it all on the line. That's what happens when the defense goes ahead and makes a substantial offer and you turn around and reject it immediately. Now you run the risk of going to trial and rolling the dice, putting all your money on one particular hand, one particular roll, hoping that the jury sees the case your way, and if they do, that the jury comes back and gives you much, much more than what the defense has offered. Now, is that a possibility? Yes, it can be a possibility. But to get there, you have to jump through many, many hoops. So my goal is to show you and to explain to you about all the risks associated with a substantial settlement offer, the risk of rejecting the offer, the risk of accepting the offer, what your alternatives are, which usually are to go to trial, and then run the risk of the unknown. Will you take what's behind door number 1, which is a definite known number, or will you take what's behind door number 2, which is a total unknown? Now, I should tell you something else. Even if you go to trial, and even if a jury comes back in your favor, and even if the jury's verdict was far in excess of what you had originally been offered by them, that's not the end of your case. You want to know why? It's because the first thing that's going to happen when you get an outrageous verdict or a substantially larger verdict than what the defense feels your case is worth, the defense will immediately jump up out of their seat and yell out, "Judge, I ask that you throw out Mr. Oginski's client's case." Why? Because it's against the weight of the evidence. A judgment non obstante verdicto. That's a fancy Latin phrase that basically says, look, the evidence is inconsistent with the testimony here. And as a result of that, we believe that your case should be thrown out. And that is a possibility. The other likelihood is that now, if the judge decides not to throw the case out at that moment, he may do so at a later time. And then, even if the judge refuses to throw the case out, there is a very good likelihood that they are going to appeal the case. And when they appeal the case, there are also many unknowns associated with an appeal. Many things can happen with an appeal. So, do you want to take what's behind door number 1? Or will you go ahead and forge through and now go ahead and take behind what's door number 2, which is the unknown? So why do I share this quick information with you? I share it with you just to open your eyes and to help you understand how these types of cases work in the state of New York. You know, I realize you're likely watching this video because you may have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit, but are thinking of doing so, and you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.